Greetings from snowy and beautiful Muskegon. As he said, I'm Joyce Elferdink. I'm a member of the Social Science Committee. When asked to pick a great decisions topic, I chose war crimes because of my interest in Ukraine. But to find a speaker, I Googled the topic and found that the Clooney Foundation for Justice was involved. Yes, that's Amal and George, their foundation. Since they had an email address, I sent them a message and to my amazement, got a reply. And that's why we have Antonia David joining us today from Washington, D.C. Antonia is a senior program manager at the Clooney Foundation at their Docket Initiative, where she's focused on seeking justice for survivors and victims of atrocity crimes. She's a lawyer working on international crime law and justice issues across various docket projects. As part of this, she co-leads the initiative's project on Ukraine, which most recently filed 3 criminal complaints with German federal prosecutors on behalf of 16 Ukrainian survivors and victims of atrocity crimes committed by Russian forces. Prior to starting her work at the foundation, she was an associate at a prestigious law firm in their New York office. Her legal practice focused on complex civil litigation in the United States, but her pro bono practice included international criminal law, human rights law, and U.S. immigration law cases. She holds a JD from the University of California, Berkeley School of Law, where she pursued various research and clinical positions focused on international law and accountability. Wow, are you as impressed as I am? If so, let's show Ms. Davis how grateful we are to have her join us today. Yay.
Thank you, Joyce, and thank you, everyone. Well, first, thank you for inviting me to speak on this topic. I was very happy to get your email, Joyce, and I'm glad we were able to make this work. But thank you, everyone, for joining today and for your interest in this topic. I know it seems from my reading of the Great Decisions program, some of these topics were picked last year, so they might seem a bit out of date, but I'm really happy to have you all here and to speak on this. So I think first I will play the video, which some of you may have already seen, but I will play the video, about 25 minutes of the video, and then I will do my portion of the remarks.
Welcome back, ladies and gentlemen, to Great Decisions 2023, an 8-lecture masterclass brought to you by the Foreign Policy Association. Here in week 2, our attention turns to the topic of war crimes. For most of us, war crimes reminds us of what happened after World War II at Nuremberg, when high-ranking Nazi and German officials were held accountable for the violations of the laws of warfare. 4 major powers, the victors of World War II, the United States, the Soviet Union, United Kingdom, and France, joined together for the prosecution of alleged Nazi war criminals. Once the process in Europe was underway, attention focused on the Pacific, with holding Japanese politicians and military officials accountable. In Tokyo, there were 11 judges, some of them with clear conflicts of interest, and also there was the shadow of Douglas MacArthur, who played an instrumental role in revising the direction of this tribunal and even changing some of the final outcomes of the judge's decisions. Today, we think of war crimes as we look at the unfolding war in Ukraine, the Russian invasion, the occupational behavior, the weaponry used on the battlefield. The evidence is being collected for possible war crimes prosecution once things settle down in Europe. Historically speaking, World War II was certainly a high point. We had the Nuremberg and Tokyo tribunals. We also had the spin-off trials, the Dachau trials, the doctors' trials, the generals' trials, the kidnappers' trials, and many, many others. A large number of individuals were successfully prosecuted. Most of them were found guilty of what they were charged with. Before that, there was an effort after World War I to also hold the Germans accountable for starting that catastrophic conflict. In fact, in 1919, we handed over to the German government a list of 1,000 Germans who we believed had committed war crimes, and we wanted them turned over to an international tribunal. This became highly problematic as our interests were equally divided. On the one hand, we did want to hold the Germans accountable individually and collectively for starting the war, but on the other, we had a vested interest in keeping the new German government together. And the thinking was that if we forced them to hand over so many German citizens, the government may lose legitimacy at home, it may collapse, and before you know it, Bolsheviks are running roughshod in Germany. So the decision was made to allow the Germans to prosecute their own citizens. We gave them the docket, we provided the evidence, and at the end of the day, those 1,000 individuals suddenly became only 12 that made it to court. 6 of them were found guilty, and the sentences were extraordinarily light. So a very bad precedent was set. After World War I, that was clearly remediated in 1945 when the victorious powers took over prosecution. The Cold War that followed was one with very few international war crimes prosecutions. The handful that did take place occurred domestically. Once the Cold War ended, however, we have an incredible increase in both the interest in and the activity of international tribunals. A tribunal for Yugoslavia was created by the UN Security Council, followed by one for Rwanda. And then at the end of the decade, in 1998 at Rome, a statute for the International Criminal Court was created. Today we have 3 main considerations before considering U.S. foreign policy options as it relates to war crimes. We begin with the concept itself. We look at the legal institutions that adjudicate, and then finally we briefly consider the track record of holding individuals accountable. We start with the concept of war crimes. What are they and where do they come from? ILOAC is the International Law of Armed Conflict. We can simply call it the laws of warfare or the laws of armed conflict. Where do these laws come from and what are they? Well, the categories are threefold. There's jus ad bellum in the Latin, which is the legal right to go to war. This is determined by the major powers of the world at any time in world history. There's jus in bello, which is the behavior in time of war, the weapons that are deployed, targeting practices, and the like. And then finally, the newest of the 3 categories is jus post bellum, which is responsibility to make things right once the war is over. We begin with jus ad bellum. The compétence de guerre of states means the right of any nation to go to war. From the onset of modern world politics until the end of World War II, there were very few limitations on the right of a nation-state to go to war. A sovereign nation-state could simply go to war for most any reason that it determined, with one exception that dates back to 1648. That's when the 30 Years' War concluded. The major powers of Europe decided that religious differences were no longer a legitimate recourse or right to go to war. And then suddenly in 1945, perhaps because of the devastation of World War II or the use of atomic bombs, more likely because of American leadership, the right to go to war was greatly reduced. This was an American decision, and it was etched into the Charter of the United Nations in 1945. So what exactly does the Charter say? It says nation-states shall not, in their relations with other states, either use or threaten to use armed force in their international relations, with the following exceptions. Since 1945, a nation may legally go to war if it is acting in self-defense, meaning it has been attacked, if it is acting in collective self-defense, which is coming to the rescue of a victim state. Think about the United States in 1950 and rescuing South Korea, or should the Security Council approve of an international conflict, which happened also in 1950, a bit after the intervention began. If a nation state commits a violation of the laws of armed conflict, it is then responsible for those violations. It isn't to say that a nation state will pay any price for breaking the rules, but it is to say that option is available. Jus in bello is a little more refined, it's much older in its evolution because it dates back to biblical times. There are four key limiting principles that apply to every nation state's military on the battlefield. The first is distinction in targeting. It's a simple matter. You may target the military of another side. You may not target civilians or non-military assets. Belligerence versus non-belligerence is the dividing line. There's a ban on weapons that cause unnecessary or superfluous injury. The purpose of a weapon is to take out another soldier, either through killing or injuring to the point that they can no longer continue the fight. There are weapons designed to cause unnecessary levels of suffering beyond that which the soldier would be able to continue. Tumbling bullets are an example. They enter the body. They're designed in such a flawed way that when they touch a bone, they begin to tumble and they move around the body, destroying organs, muscles, and other vital, life-necessary components of the body. Principle number 3 is called proportionality. They used to say in graduate school that you can't kill a mosquito with a sledgehammer to demonstrate the rule of proportionality. What this means is you can use enough force legally to win the war, but you shouldn't overdo it. You don't continue to destroy the enemy after the battle, after the war is over. And then finally, there's an international prohibition on perfidy. Perfidy is difficult to explain on some levels because it's unfairness in warfare. It's exploiting the trust of the other side. For example, if we were to enter enemy lines with a Red Cross symbol, we're making the opposition think that we're doctors and nurses there to help them as neutral actors, and in reality, we're transporting armed troops or weaponry across boundaries, or pretending to be a priest in warfare. Priests may not be targeted, so we dress up as a priest so we avoid targeting, and that gives us an unfair advantage on the other side. Soldiers in professional militaries today are not really trained in Hague and Geneva law. They normally don't speak Latin and understand the intricacies that are laid down in the laws, but they are professionally trained. And in that training, they understand concepts such as honor and code. That honor and code reflects the laws of armed conflict and those jus in bello principles. So where did these laws come from? Ancient religious writings, I mentioned the Bible earlier. Philosophers, military elite have played a critically important role in defining the laws that apply to their soldiers, statespersons, and diplomats that negotiate these rules with other nation states. If we consider the Hague Conventions of 1899 and 1907 as the first truly modern, comprehensive view of the laws of war, Geneva of 1949, those four conventions are the most modern application. And what we find is that military field manuals of professional militaries reflect the principles laid down at Hague and Geneva, and therefore have a great influence on soldiers on the battlefield. We now turn our attention to legal institutions. If there is a war crimes trial, overwhelmingly, 99% of the time, it happens in domestic courts, not in international tribunals. The Eichmann trial of 1961, the author of The Final Solution, who was captured in Argentina by the Israelis, taken back to Israel and prosecuted quite publicly. He was the man in the glass box for his own safety. That happened in a domestic court. The same goes for Khalid Sheikh Mohammed, one of the architects of 9/11, held in the United States and prosecuted by American courts. International tribunals do exist. Historically, they've been ad hoc or temporary for a particular purpose. That was Nuremberg and Tokyo, Bosnia and Rwanda tribunals, Sierra Leone, Cambodia, Liberia, among many, many others. Tribunals created for a specific purpose, even at times for a specific individual, and then once that trial is over, those tribunals shut down. On the permanent side, we have only the International Criminal Court. Technically, the ICJ, the International Court of Justice, can prosecute a nation state for violating the laws of warfare, but it's much more likely that such a prosecution would happen in the ICC. The impact of these tribunals on the development of international laws of armed conflict is important because Yugoslavia and Rwanda were created in the 90s at a time when the old Geneva law was not very specific. It was exceptional for training manuals, but it was too vague for a court of law. So those two tribunals provided amazing levels of specificity, creating delineations, definitions, outlining exactly where the laws end and where the new set of laws begin. So their impact on the laws was remarkable. By the time the International Criminal Court in The Hague began to function, the laws were ready for the courtroom, and it simply took them in new directions. Our policy towards the International Criminal Court evolved in interesting ways. The senior George Bush, shortly after the war in Iraq ended in 1991, went to the United Nations General Assembly and proposed the creation of a permanent international court, a court that could hold individuals accountable. He was obviously thinking of Saddam Hussein. Then the United States refused to ratify the treaty nearly a decade later when it was complete. The Clinton administration left that for its successor, but it did sign the document on the way out of the White House in 2001. The younger Bush administration, W, then promptly unsigned the same document, which is the legal equivalent of unringing a bell or unspilling milk. Something's happened, you've signed, you can't really go back and erase your signature. So what we effectively did was announce to the world that we're not going to implement the ICC protocol and we're not going to submit it for Senate ratification. And then we went to war with the ICC. Not long after George W. Bush said, we're not going to join, but we're not going to undermine, we sought to undermine the court in every way possible, drafting domestic laws that precluded the U.S. from any assistance in ICC prosecution. And what that means is we're not going to turn over evidence. Or if we have alleged war criminals in our jail system, military, of course, we're not going to hand them over for prosecution. And a part of that law, the APSA, was a provision that allowed the U.S. president to use any means necessary to rescue an American in ICC detention. The ICC is located in the Netherlands, which is a fellow NATO member, so the critics referred to this document as the Invade the Netherlands Act. Finally, we consider the track record of prosecuting alleged war criminals. Here we have the three basic categories of individuals involved in armed conflict: soldiers in the field, military command, and then the head of state. During World War II's prosecutions, Nuremberg and Tokyo, this graph was expanded dramatically. Newspaper editors, industrial elites, politicians at lower levels were all indicted and held accountable for their support of the Nazi regime and its goals in World War II. But today, for most trials, the individuals come from these three categories. War crimes allegations are overwhelmingly found at the field level. And naturally so. This is where soldiers commit acts that may not be legal. They can use weaponry that is deemed outside the bounds of legal acceptability. And I'll give you an example of how the rules are drafted and how difficult they can be to apply. Consider the serrated knife. A serrated knife, which has the edges near the handle, is perfectly legal. It's a tool and it is a weapon. If it's used as a tool to cut cloth or rope or a tree branch, it's perfectly legal. But the moment that it is used as a weapon, it becomes a violation of the laws of war because those serrated edges cause superfluous injury to the targeted individual. It's no different than a blade that is on one's hip. That's perfectly legal because blades are a necessary weapon of war. But according to the laws, if you attach it to the end of a rifle, it's now illegal as a bayonet because of the superfluous injury rule. So it's at the base level, the field level, the soldier level, that most war crimes allegations are made. They can be at low levels or high levels, and occasionally members of military command are accused of committing war crimes, as are heads of state. Heads of state have been prosecuted after World War II, at Tokyo in particular, but also in some of the ad hoc tribunals of the 1990s and beyond. If it's at the head of state level, it's probably the allegation of an illegal invasion. Vladimir Putin is vulnerable to that charge today. If it's at the military command level, orders to violate the laws of war. If it's about bringing to trial, then suddenly our graph changes because overwhelmingly it is going to be people on the ground level, the soldiers in the field committing acts that are deemed to be illegal. In terms of convictions, our space gets much smaller. Very few individuals are successfully prosecuted for breaking the laws of warfare. As noted earlier, 99% of all trials are done at the domestic level, and usually it is the national or military court of the individual being prosecuted. And so they tend to go out of their way to understand the situation on the ground, to give the soldier every benefit of the doubt. The prosecution rate is remarkably low. Even when the evidence is overwhelming, thousands of pictures of torment, of torture at Abu Ghraib prison in Iraq following the 2003 American invasion really didn't move the dial very much. A small handful of ground-level American soldiers were prosecuted successfully for violating the laws of war, but no one at the military command or higher level. Keeping in mind that when you read the memoirs of George W. Bush, he openly acknowledges that he approved of enhanced interrogation techniques, which is a very long-winded way of saying torture, because we define these actions as torture before Iraq and we do so afterwards. We can't simply make an exception when it is convenient for us when these pictures hit the newsstands. The invasion of Ukraine by Russia in February 2022 brought this topic to great decisions level this year. The invasion was significant. In early days, it looked overwhelming. The tide of the war changed very quickly, and the behavior became more and more prohibited on the Russian side. So let's take a look at Russia's war crime record in Ukraine. The invasion was clearly illegal. Ukraine did not attack Russia. It certainly did not invade Russia. There was no self-defense, no collective self-defense, and there was not a Security Council authorization. Commission of war crimes is widespread. The evidence is overwhelming. There's clear evidence that crimes against humanity have occurred. The difference between a war crime and a crime against humanity is that the latter is a pattern of systematic violation of the former. So one war crime in and of itself is adjudicatable. If it happens over and over as part of a systematic process, that means it's a crime against humanity. The laws of belligerent occupation have been violated, and there's an enormous tab that's coming due for the Russians once this war is finally over, the post-conflict destruction or jus post bellum. What will happen to Vladimir Putin once this war ends? It's quite possible that he will never be held accountable. He will remain in power like most leaders have. The vast majority of state leaders that have authorized an illegal invasion have not paid a legal price for it. There could be a domestic response. Perhaps the Russians get tired of Vladimir Putin in office, pursuing this war of folly, of great economic and physical pain for the Russian population. They could use the war crimes allegation as an excuse to remove him from power, pushing him out and holding him accountable. There's also the possibility of an international tribunal being constructed specifically for this conflict, or the International Criminal Court being used. An example here is Slobodan Milosevic. He was the most powerful force in Yugoslavia throughout the 1990s. He oversaw the disintegration of Yugoslavia, the invasion of Croatia, the invasion of Bosnia, and then in 1999, the war in Kosovo. He was seemingly out of reach until his own political allies decided he's too much luggage for them. They would rather get rid of him. And so they ushered him into a waiting automobile and they shipped him off to The Hague, Netherlands for prosecution. And there you can see him as defiant as ever during his own prosecution, but certainly reduced in terms of his impact, in terms of his aura, in terms of his reputation. He died before the verdict was issued. We now turn to U.S. foreign policy options, and in so doing, we have some nested issues. There is Russia and the ongoing war in Ukraine, the broader issue of the International Criminal Court, and then finally the week 2 great decision of war crimes. We'll look at these in order, beginning with Russia. Holding Russia accountable for its violations is somewhat important, particularly the jus post bellum, the destruction of the state of Ukraine. By estimates as of November the 8th, the day that this video was filmed, the tab has already surpassed $1 trillion in damage. And there really is not an end in sight for this conflict, nor for the amount of destruction that Russia is causing. Let's look at war outcomes and Kremlin politics. If this war ends in territorial compromise, as Henry Kissinger and many other realists have argued, there's a very real possibility that Vladimir Putin would stay in power. He would spin it in such a way that this was a successful war. It won't be true, of course, but it may be just enough to keep him in power. If the war ends with Russia losing all of its territorial gains, and that would be Crimea, as well as the Donetsk region in eastern Ukraine, it would be very hard for Vladimir Putin to stay in power. This would be a clear war failure. It would be very hard to spin in any other way, and that could make him vulnerable, much more so than the territorial compromise option for war crimes prosecutions. If it turns out that the Western world wants Russia to truly pay for its invasion of Ukraine, and by that I mean not only losing all of the Ukrainian territory that it controls, but also, for example, Abkhazia in northwestern Georgia, making the Russians pay economically into the foreseeable future, then it's very, very difficult for Russia to maintain its leadership position. I mean, Putin would have to be out. There would have to be a transition of power, and that makes the likelihood of a war crimes prosecution for Putin even greater. Looking at the International Criminal Court, it's interesting to watch how Americans debate this, especially U.S. senators. On one side of the spectrum, usually Democrats, there's an argument that we have a moral obligation to join the International Criminal Court. That's not true. And then on the more conservative Republican side, they view the ICC as a threat to the United States, which also isn't true. The real issue is the debate in between. Where do we find the cost-benefit analysis? Is it in the U.S. favor? There are costs to joining the ICC, and there are benefits. The costs are not as high as the ICC being a threat, nor are the benefits as high as American moral global leadership. They're much more technical and specific, and that is the area that no one debates, certainly not elected politicians. In the Senate, of course, they're responsible for ratifying the document, should it be submitted. So it's a bit of a hollow debate that happens in the U.S. relating to the ICC, and for that reason, the likelihood that we will join in the coming, say, quarter of a century is amazingly low. And finally, we look at the topic of war crimes, our great decisions this week. I'd like to frame this in a...
Okay, I'm going to stop it right there. There's only about 4 minutes left, 4 or 5 minutes left in the video, and I'm going to kind of go from there and have you be able to watch the video to its conclusion if you would like at a different time. I wanted to show sort of the first 25 minutes of this because I thought it gives great sort of historical background, especially sort of the American approach to this, the US's position sort of vis-a-vis certain war crime issues, international justice issues. So I have some clarifications on some of the points that were made in the video, but overall I thought it was pretty good kind of historical view of the last about century for international justice. So to get to my piece of this, so as Joyce said, my name is Antonia David. I am a senior program manager at the docket. I'm a US lawyer, but I've been working mainly in international justice issues. And since about March 2022, so over a year and a half ago, I've been co-leading our Ukraine project at the docket. And so the docket is part of the Clooney Foundation for Justice, and it's the part of the foundation that specifically focuses on accountability. So accountability and justice for victims of mass atrocities, which includes, of course, war crimes. Our team is a mix. It's a mix of lawyers, investigators, analysts, and others who work in this area. And we primarily conduct investigations and fieldwork in order to essentially put together dossiers or criminal complaints, criminal submissions, and then hand those off to national authorities, so prosecutors or law enforcement, either in various countries or at the International Criminal Court, so that they can conduct sort of their official investigations, and we can find ways to support them in doing those investigations. So sort of the scope of what I want to talk through today. Sorry. As I mentioned, so I want to give a little bit more context and a little bit more color to some of the issues that came up on war crimes or international crimes in the video. I want to talk a bit about, since it's now been almost a year since that video, or a little bit more than a year, I want to talk a bit about the accountability mechanisms that have already been set up for Ukraine and that are operating or that are sort of in the initial processes of being set up, since there's been a lot of development over the last 12 months. And then the last piece of this, I want to take some time to walk through cases that we have been working on for a year and a half, and that at the end of last month, October, we submitted to the German federal prosecutor to begin investigations, hopefully. So those are the three main things I want to talk through today. Like we said at the beginning, I welcome any questions. I would love to sort of get through these points and then do sort of an extended Q&A at the end, so that we have sort of all of the information and we can talk about it holistically. So before I dive into the substance, I wanted to kind of put out three things that you see there on the right of the screen about sort of my position in this and where I come from, both personally and at the docket. So the first is that in the work that we do, the survivors and the families of the victims are sort of central. So the people and the families who are affected by these crimes are kind of driving the work that we do. I think, especially reading the news or seeing some of the analysis about the number of war crimes or the number of possible investigations and prosecutions for war crimes, it can often sort of have a numbing effect of what has actually happened on the ground. And things like war crimes can feel a bit theoretical or political, even something that, Congress discusses, the UN discusses, or, professors discuss. But I sort of want to center my part of this, and just for you to know that my perspective on this is very much victim and survivor focused. Those are the clients we have. Those are the people I work with directly. And so their sort of experience of war crimes, which is usually, the worst day of their life, the worst week of their life, whatever may have happened to them, is sort of why I do this work and how I approach the topic. So that's the first point. And then the second point is that war crimes are part of sort of the international criminal law framework. They're one component, right? It was mentioned in the video. Another component is crimes against humanity. A third one is genocide, which did not come up in the video. A fourth one is the crime of aggression, or the type, starting a war. So those crimes are part of a whole legal framework, and we'll get into pieces of it. But that framework can be applied in any context. So there's a lot of conflicts that are happening. Ukraine continues to be at war. Over the last year, we've had Ethiopia, Sudan, we've had Gaza, Israel, Palestine. And in all those situations and many others in the past century and more, you can apply sort of this legal framework to analyze whether there may have been war crimes. I just want to say for today, I'm really going to limit my remarks to Ukraine and Ukraine only, because that's what I've been working on for over a year and a half. Okay, so that's what I've been working on for a year and a half. So I really want to focus on what happened, what happened, what does the accountability space look like for Ukraine, and what have we been doing? Yeah, so with that, into the substance. So in the video, you heard sort of discussion of various bodies of law around war crimes. And then throughout my part of this, I usually refer to things as international crimes or core international crimes or the most serious international crimes. They're all shorthand for essentially 4 crimes. War crimes, crimes against humanity, genocide, and the crime of aggression. They're all, it's just my shorthand of referring to things. So please bear with me on that. There's 2 additional points I wanted to make in addition to some of the framework we heard from the videos. The first of these is that people, not countries, commit war crimes. So this idea was really born around, as we heard, the end of World War II, where international criminal law as sort of an accountability mechanism for the atrocities that happened was born. And there was this recognition that it wasn't states, these abstract political institutions or entities, it's not states who are committing crimes on the ground. States aren't holding, guns to people's heads or committing sexual violence or torture. It's people. So it's soldiers, it's their commanders, who are carrying out orders or on their own initiative, committing these crimes. So the very concrete idea of international criminal law is to be able to hold individuals accountable for these sorts of crimes, either because they themselves, for example, pulled the trigger, or they ordered someone to commit those crimes or stood by watching while someone committed those crimes. So it's very, it allows these mechanisms to hold individuals accountable, right? We're no longer talking about states and what states are doing, but we're kind of talking about heads of state, we're talking about commanders, we're talking about soldiers on the battlefield. And that's a very unique component of international criminal law. The second piece of this is that not all crimes committed during a war are war crimes. So to understand this, I want to talk a little bit more about the individual elements of war crimes and also crimes against humanity. I didn't love the crimes against humanity definition during the video. It's not quite right, but we're gonna kind of take a look at it in more detail. Okay, so I'm not gonna go, this is not a law class, I know that, even though as a lawyer, I might want to make it such, but I am trying to take the legalese out of this and really strip it to the main components of what makes something a war crime versus just a crime that happened during a war. So there are 3 main components that apply to war crimes. They also apply to crimes against humanity and genocide. Aggression is a bit different. We're just going to leave that one to the side for now. But okay, so 3 main components. The first of which is the crime itself. So this is similar to any other crime that might be committed. You have a physical act, you have a mental element. So I'm sure many of you know this, even something like Law and Order gets this perfect, right? You have an actus reus, someone pulling the trigger on something. Again, you have a mental element, a mens rea, the person wanted to commit the killing, or they knew that if they pulled this trigger, they were going to kill someone. I'm just going with the killing example for this, just for ease of example. So that's the actual crime. That kind of crime is very similar to any crime that happens in peacetime or in wartime. So you have your crime base. But what makes it an international crime, what makes it a war crime, what makes it a crime against humanity is that that specific crime takes place in the context of something else. So for a war crime, it's that specific killing took place in part of or in furtherance of the war. whether it's an international armed conflict like a Russia-Ukraine, or it's a civil conflict. Parts of Ethiopia and Sudan probably qualify as that. So the specific crimes that are happening are in part of that bigger conflict. They're not isolated, they're not random, they are sort of part and parcel to the war effort, essentially. The contextual piece for crimes against humanity is that the specific killing, again, is part of a pattern. So the requirements here are that it's part of a widespread or systematic attack. So that could be that it's kind of geographically widespread, or just widespread within even a small geographic area, but basically that there's a pattern to it. It's happening over and over again. That it's against a civilian population, so not against soldiers or military, but against civilians. And that there's some sort of government policy that's driving this, either explicit or sort of an indirect component, but there's some sort of directive that people are following to commit these crimes. So a little bit different for war crimes, crimes against humanity. War crimes are also only in war. Crimes against humanity can happen both either in war or in peacetime. It doesn't have to have that war link. But both have these contextual elements that make it an international crime. So, for example, what would not be a war crime is if someone is just randomly looting, a TV from somewhere, and it's not something everyone in the unit is doing or everyone in the army is doing. They just, wanted to take home a TV as war spoils, essentially. That would not, count as a war crime, sort of under international law. The contextual elements are really, really important. So I really want to emphasize those. And then the third component for all international crimes is this motive liability. So basically, we have a crime, we have context, who did it? We have two different versions of this, and you heard a bit in the video. We have the direct perpetrator. So in our killing example, it would be the person who pulled the trigger, essentially, who committed the execution. And then we could also have indirect perpetrators. So this is where this idea of command responsibility, superior responsibility comes in. So indirect perpetrators could be commanders who are responsible for their unit. The military is very organized. They have a lot of training. And there's a lot of hierarchy and rigidity, as it should be in the military, and so commanders have sort of responsibility for their unit, to know whether they are committing any violations, and to either stop it, or if the violation has already happened, to essentially investigate and punish if necessary for any violations committed. So indirect perpetrators can be commanders all the way up the chain of command. And they can also be superiors. For superior responsibility refers to what the video mentioned. For example, after World War II, there were a lot of newspaper editors, business executives, and kind of non-military civilians who nonetheless were aiding the war effort, and who were making weapons, who had sort of influence over some of the violation, and therefore superior responsibility is for those sort of civilians who are in positions where they can direct others. Maybe too much detail, but just to sort of lay out the basics. You have the crime, you have to have a contextual element in which the crime is occurring, and then you always have to have essentially a perpetrator. Who did it? The direct perpetrator or the indirect perpetrator, or both. There are some situations where you can, you'll be able to hold both the person, for example, who pulled the trigger and their commander for not doing something about it, responsible. It's a very simplified scenario, but just to sort of paint the big component of this. Okay, so with that, I want to look a bit more into to walk through what has already been happening for Ukraine, because there's been a lot that's developed over the last year. And to start with, we'll start with the International Criminal Court. So The International Criminal Court, or the ICC, officially opened an investigation into the crimes that Russia may be committing on Ukrainian territory on February 28th. So this was 4 days after the full-scale invasion. However, they had been conducting a preliminary investigation even before then. So the scope of their investigation time-wise actually goes back to November 21st, 2013, which is about before Russia annexed Crimea. And so the ICC is actually able to look at everything that has happened since November 21st, 2013 as part of its investigation. As far as we understand it, a lot of their efforts have been focused kind of in the last year and a half of what has happened since then, just because the scale of the potential crimes that are happening obviously greatly increased with the full-scale invasion. But they do have the ability to look before that. Ukraine, similar to the US, Ukraine is not a party to the Rome Statute, which is the protocol of the International Criminal Court, but it essentially accepted the jurisdiction of the ICC. So it notified the ICC that it's willing to submit itself, provide evidence, provide access to the ICC, and allow it to conduct its investigation on its territory regarding any crimes that have been committed there since 2013. And you may have heard earlier this year, this was in the news quite a lot, of the 2 arrest warrants. So in March of this year, the ICC issued its first arrest warrants for the case of Ukraine. It was 2 arrest warrants that were issued for 2 different war crimes. The forcible transfer of a population and the unlawful deportation of a population. And those were focused on children. So moving children from Ukraine to Russia. And these arrest warrants were issued against 2 people, the president of the Russian Federation, Vladimir Putin, and then the commissioner for the children's rights, a fairly high-ranking kind of political office in Russia. And the arrest warrants essentially alleged that the 2 of them conspired and knew about sort of the bigger policy around planning to move kids out of different areas of Ukraine into Russia and then keeping them there. The fact that Putin and the commissioner were named in this shows sort of the reach of the ICC. So the ICC, per its mandate, per the Rome Statute, can only go after really the very top level of decision makers. So you see, right, the president and the commissioner, very high political offices. The ICC is really meant as a court of a type of last resort court. It's not going to go after individual soldiers. It's really going to go after the people who were mainly involved in making big decisions. So these 2 arrest warrants are great examples of what the ICC does and tries to do. And just here, I wanted to note at the bottom, also a change from within the last year, the US has actually agreed to cooperate with the ICC on the Ukraine investigation. There's not a lot of details that have been made public about it, except that the US has agreed to do this and is essentially sharing evidence with the ICC on information on war crimes that Russian forces may have committed in Ukraine. So it's kind of it's not quite, of course, becoming part of the ICC, like the video said, right? It's probably very unlikely to happen anytime soon, but it's sort of I think personal opinion, a good step for the US to be more involved in accountability proceedings that are very important. Okay, slide. The second part of this that has not been set up yet, but has been under a lot of discussion, is the discussions around setting up some sort of hybrid international regional tribunal for the crime of aggression. So the crime of aggression would be about starting the war. As we heard in the video, there's different frameworks for starting a war, laws during war, and laws after war. This would be about holding anyone accountable for starting an illegal war, essentially, starting an act of aggression. And the reason there's been so much debate around this is that there's essentially an accountability gap. So the ICC, even though the ICC has the ability to prosecute the crime of aggression, it does not have essentially jurisdiction. It doesn't have permission to go after Russia because Russia is not a state party to the ICC. So very big gap, and some, highlight some of the limits of the ICC. So the ICC would not be able to go after Russia for starting this war of aggression. Similarly, or not similarly, but Ukrainian courts would also not be able to go after Putin or any very high-ranking official. Because Ukrainian courts, they're domestic courts, and there is international law around trying to prosecute heads of state and other very high-ranking officials in national courts. Essentially, if they were acting in their political duties as heads of state, they cannot be prosecuted in domestic courts of any other country. They have an immunity, essentially, from doing that. There's lots of very interesting case law around immunities, but the gist of it is Ukraine would not be able to, in its national courts, would not be able to prosecute Putin for the crime of aggression. And so you can't do it in Ukrainian courts, you can't do it at the ICC. So there's been a lot of discussion around, do we set up some sort of hybrid tribunal, as has been done before? The video mentioned the Rwanda, Yugoslavia, Sierra Leone tribunals. Some of those were able to go after sort of high-level heads of state. And so it is a possibility of setting up something similar for Ukraine. It has not actually been set up yet, but what the international community so far has agreed to do is they set up a precursor, essentially. It's called the International Center for the Prosecution of the Crime of Aggression Against Ukraine. Very long title. And it was established earlier this summer at The Hague. And essentially what this center is doing is collecting information. So they are collecting evidence, they are storing and preserving it so that in the future, if there ever is a tribunal set up for aggression, or possibly there's some way to work around the limitations of the ICC or Ukraine national courts, the information is there and it's being preserved and it can then be handed off to someone to do the actual prosecution for the crime of aggression. So there's still a lot to do around the tribunal, but there has been this intermediate step of setting up at least a center to collect and preserve information for the future. So the third accountability mechanism that's been very active has been Ukraine's own domestic courts. So unlike other recent conflicts, I'm thinking, for example, Syria, because I've worked on a few of those cases, where sort of the conflict began and the domestic system essentially collapsed and wasn't able to do investigations or prosecutions, understandably. In Ukraine, it was actually different. So even though the war broke out, Ukraine's prosecution offices and law enforcement and national police have essentially been able to continue working quite differently than they were working before the war, but working nonetheless. They essentially say everyone became war crimes investigators overnight, which is true. And so under Ukraine's criminal code, they're able to investigate and prosecute war crimes, genocide, and aggression. Not quite in all three of them in the sort of international crimes sense. There's some gaps in the code, but they're able to do investigations and prosecutions. And they've been able to get a lot of international experts to assist and kind of build capacity, do trainings in both sort of law enforcement, with judges, with prosecutors, and things like that. So they're able to proceed with cases. I have a few numbers down there. So this was before Thanksgiving, so as of 2 weeks ago, they had registered over 100,000 war crimes cases since the start of the war. So since February 24th, 2022. It's an insane amount of cases. Everyone, understands that and knows it. Of those cases, 119 have full investigations. Many others have some pieces of the investigation going, but here I'm sort of talking full investigation, sort of joint cooperation between the police and the prosecutors to conduct the investigation. Those 119 investigations have 450 suspects for war crimes. 83 cases have been filed with the court, essentially to start proceedings. And of those, 67 have led to convictions. And this is all for war crimes only. So they are continuing to work, but sort of the reality is, and everyone we talk to, prosecutors or law enforcement, knows 100,000 cases is impossible to investigate and prosecute, even if they do take years, as they should. So there's going to have to be different ways of approaching some of these cases, whether it's through the ICC, through a tribunal, some in Ukraine's domestic courts, and then possibly some in the fourth way I would like to talk about, which is in domestic courts outside of Ukraine. So the video mentioned this a bit, and I pulled some of these headlines. I know they're very small, you don't have to read them. I pulled some of these headlines from the last 2 years, year and a half, about different countries that have opened investigations into possible crimes that Russia is committing in Ukraine. So we have certain Eastern European countries, Poland, Romania, Slovakia. We have Baltic countries, Lithuania, Latvia, Estonia. We have Germany and Sweden and Spain. We even have Canada opening an investigation. So you may have seen this and wondered, how is it possible that a country who didn't commit the crimes, and who also, no one committed crimes in Spain related to the Russian invasion. So the crimes were not committed on their territory, but how these countries are able to open investigations into crimes in other countries. So I want to talk a bit about the principle of universal jurisdiction. So universal jurisdiction, or UJ for short, is essentially a tool that's been around for almost a century. It's been around a while, probably since the birth of international criminal law after World War II. But it's really been something that has been talked a lot about since the invasion of Ukraine, and since we've been talking a lot about what does accountability look like, and what do all the puzzle pieces look like for accountability. And the idea is that it refers to cases where countries can open investigations into the most serious international crimes, even if they were committed outside of their own borders, and even if they were committed by someone who is not a national of that country, the victim was not a national of the country, the perpetrator isn't in their country. It really is a very expansive concept that requires no connection in its purest form. It requires no connection between the crime and the country investigating. So to dive into a bit more detail, is it includes the same crimes we've been talking about, and really only these crimes. So this is not something where, if I commit a crime tomorrow, Spain is going to come investigate me robbing a bank or something. It really is limited only to the core international crimes we've been talking about, which includes war crimes. So genocide, war crimes, crimes against humanity. Aggression is up for debate, but I've included it on the list. So this idea extends only to these core international crimes. And it's because these crimes are so awful, so heinous, that they're considered an attack against the whole international community. And that the idea is that we want every country and any country to be able to prosecute war criminals, to give them no safe haven anywhere, so that they cannot move and live freely anywhere in the world, because really they're enemies of mankind because they've committed these awful violations. So that's sort of the theoretical thought behind the principle of universal jurisdiction. And there's a few different ways it's been implemented. So the absolute universal jurisdiction, I promise this is not going to be too technical. I'm really trying to keep it light. But absolute universal jurisdiction is when a country basically takes that original idea of universal jurisdiction and implements it in their domestic criminal code as such. So they are not going to require any sort of connection between their own country and the crime. They're able to sort of broadly interpret and investigate and prosecute these awful crimes. There's about 36 countries in the world that have absolute universal jurisdiction that really have a broad freedom in investigating and possibly prosecuting these crimes. But then there's many other countries in the world that have added some sort of condition that limits their interpretation of universal jurisdiction. So some countries require, for example, that the possible perpetrator is in their country before they'll open an investigation, or that the possible perpetrator is a national or lives in their own country. Or that the victim of the crime was a national of their country. So there's many countries have sort of, interpreted limitations into the principle, which is sort of out of practical reality and necessity to be able to, limit their resources and be able to do something if, for example, the perpetrator is present and their country allows it. I was part of a big research project last year where we mapped all of these laws across 216 countries, including all of the UN member states. And our research showed that 148 out of 193 UN member states, so that's about 3/4 of the world, 3/4 of the world has a way of investigating these atrocity crimes that were committed outside of their own borders. So it's a pretty it's a lot of the world. Many countries in the world are able to do this. There's two examples I want to briefly talk about, just to put a bit more put it a bit more concretely. So universal jurisdiction, what it looks like in Germany, and then what it looks like in the United States. So universal jurisdiction in Germany is sort of very broad and absolute and open. So Germany has had various forms of international crimes in their criminal code. The most recent one from 2002 is incredibly expansive and incredibly friendly for survivors and victims who are looking to seek justice. They have what is the absolute universal jurisdiction principle, where, for example, for Ukraine, right, they can open an investigation even if the victim is Ukrainian, the perpetrator is Russian, and no one is in Germany, and there's no sort of connection to Germany. They're still able to open an investigation if they choose. They have also, in the last 3 decades especially, really extensively developed their practice. So they've heard many cases about international crimes, and they've established this mechanism called a structural investigation, which allows them to, for example, they did this for crimes committed by ISIS in Syria and Iraq. They opened in a structural investigation where they were able to take in an incredible amount of information from their own law enforcement, other law enforcement, organizations, international organizations, local NGOs working on these issues who might have information about crimes, and then build out specific cases around perpetrators. They were especially good at developing cases relating to ISIS. It was helped by the large amount of Syrian refugees who went to Germany. who brought with them testimonies and evidence on their phones, photographs, documents, to help German prosecutors build these sorts of cases. So they've had sort of all the countries doing these sorts of cases, they've had a lot of practice and a lot of development of the law, which has been really great, and have been some of the leading cases for, you know, finding genocide and protecting minority groups that ISIS especially targeted. So it's quite encouraging to see. And then briefly to take a look at the United States. So United States, as we all know, not quite as expansive as Germany or other countries. But the US did recently do a fantastic job at closing a big loophole, which was in the War Crimes Act. So in January of this year, there's a new version of the War Crimes Act that came into force in the US. And it essentially included, it allowed US law enforcement to arrest, investigate, and prosecute anyone who's might have committed war crimes who is present in the US. So before this, the War Crimes Act was much more limited. It only let law enforcement do those things if the perpetrator was a US national or a US resident, or the victim was a US national. So you can imagine a situation where, looking at Ukraine in 5 years, for example, if a Russian commander who may have committed war crimes wants to vacation in Florida or some other US state or territory, US authorities would not have been able to do anything to arrest them. And so with this new amendment, it sort of closes this loophole. Anyone who is on US territory who might be a alleged war criminal, the US would be able to act and investigate and potentially prosecute that person, which is a huge step in accountability and justice. The US also has a Genocide Act, which similarly has a presence. It already came with a presence allowance. Anyone who's on US territory who may have committed an act of genocide can be prosecuted. One of the big gaps in the US still is crimes against humanity. However, there's been a lot of discussion and a lot of efforts that are currently supported by the State Department here to push the US to also criminalize crimes against humanity. And I was hoping to have some updates by the time of this presentation, but unfortunately there aren't any yet. But I'm hopeful for the next short term, I guess, and we'll see if we get Crimes Against Humanity Act of some sort in the US. So like I mentioned, just wanted to highlight this briefly. We ended up mapping universal jurisdiction across the world, essentially. If anyone is interested, I only highlighted Germany and the US today. If anyone is interested in kind of mapping more of this, learning more, understanding some of the historical trends for universal jurisdiction, I invite you to go to Justice Beyond Borders. That's our mapping tool. It has a world, and you can click into each region and country and learn more about each country. Just wanted to highlight that since some of you might be interested in more. Okay, so that brings me to the third part of this, which is what have we been working on, and what have we been working on specifically vis-a-vis Ukraine. So I spent a bit more on universal jurisdiction than the other mechanisms, just because that has been our strategy. So the docket has really been focusing on universal jurisdiction as the accountability mechanism. And the reason for that is that we sort of see a bit of a gap, a potential gap, because Ukraine's sort of walking through the mechanisms we talked about. Ukraine, its domestic courts are really focused very much on who are they able to get, who is on their territory that they might be able to investigate and prosecute, And then some of the limitations in their criminal code require them to really focus on direct perpetrators, so the low-level soldiers who pulled the trigger, or if they have evidence, like really direct evidence of a commander giving that order. So it's very limited to who you might be able to prosecute for a war crime. The hybrid mechanism, like we said, it's sort of limited to the crime of aggression at the moment. Discussions are really just about aggression. There does not seem to be discussions really about a tribunal for all of the international crimes, which would include war crimes. So it's limited to aggression. And then, as I also touched on a bit, for the International Criminal Court, their focus is the highest of the highest level of officials and commanders. So they're going after Putin. They're going after the big generals of the military. They will not be going after anyone lower. They're going to have if all goes well, they will have a handful of cases relating to Ukraine. They will not be prosecuting hundreds and thousands of cases. So kind of looking at this landscape, we thought there was a bit of a possible gap of commanders, largely mid-level, high-level commanders who are involved in giving orders, who are responsible for their troops, their units, their soldiers, and who either ordered and directed soldiers to commit violations or were sort of tacitly part of it. They knew it was happening. They didn't do anything to stop it, things like that. So our approach has been to use universal jurisdiction, so going into other countries outside of Ukraine, to try to build cases against these commanders. So really going up the chain of command. So wanted to spend some time just on universal jurisdiction to explain that piece. So how we work. The biggest part of our work is investigation and field work. So like I said, our team consists of investigators, analysts, and lawyers. And our investigators essentially work in the field. We have investigators in Ukraine who interview eyewitnesses and experts about, either the crimes that they witnessed or were a victim of, or any units that they saw in the area, perpetrators and the like. We look at documents and any materials that Russian forces may have left behind as they were retreating. In many places, especially where they occupied towns for a long time, they left a lot of physical evidence that, of course, Ukrainian authorities are collecting, but it's in some places is still there as well. And then we take photographs and videos from the scene to map out where the crimes may have occurred. We also supplement the field work and our investigation with online investigation, so open source digital investigation, with satellite images, geolocation of the crime, geolocation of how troops were moving into Ukraine. And then we, of course, also partner with Ukrainian NGOs and other partners. So Truth Hounds is a fantastic Ukrainian NGO. They do amazing work. They've been documenting and building cases for war crimes since 2014. So they have an extensive experience in doing these sorts of things. And so we have a lot of cases where we partner with them in our investigation. And they've been essential in doing this work. So as I mentioned at the beginning, I think as Joyce said too, we just finished building 3 cases that were submitted to the German federal prosecutor for investigation. And I want to take some time to walk through one of them in detail, sort of in my last bit here. So in this particular, I want to talk about sort of the pattern of persecution in the Kyiv region. So we came to this case because we were working with our partners investigating this area outside of Kyiv. And it was an area of about 23 villages that was on sort of the suburbs outskirts of Kyiv. And in March 2022, when Russian forces were invading from the north and from the east, and were trying to get to Kyiv, but couldn't get to Kyiv because of Ukrainian defenses, a lot of these Russian forces essentially settled in and occupied the area outside of Kyiv. And so we documented information on 18 villages in this small region of 23 villages where Russian forces occupied for about 5 weeks. And so after of course the liberation, our investigators were there talking to people, and what they found was sort of a pattern of violations. Spoke with many people across the 18 villages, and what we heard was that there was kind of a pattern to everything, which was there was a certain when Russian forces were coming in, when they were entering the village, they would shoot at vehicles, homes indiscriminately, killing and injuring people. When they came to occupy, they moved into houses, sometimes kicking out residents. They conducted house-to-house searches, sometimes detaining people, torturing them, killing them if they thought maybe they were giving information to the Ukrainian military. There were also instances of sexual violence during those times. They executed people pretty frequently. And then as the area was liberated and Russian forces left, they essentially burned many of the houses as they were leaving on the way out. So there was this consistent pattern across 18 villages, right? So it's not random crimes happening in random villages. It was a geographic area, consistent pattern of violations, same units involved. We were able to identify the specific units that were in that area occupying during the whole time, essentially controlling the area, and able to identify the 5 commanders who were in charge of those units and who should have done something to stop it, essentially. And so the war crimes and crimes against humanity we identified are on the slide here, but it sort of spans the range of violations. And because they were sort of happening consistently, systematically, they were happening throughout the area, and they were all done by these 5 commanders in charge of the units. We also identified sort of a pattern of persecution against Ukrainian nationals, just for being Ukrainian civilians. So that was one of the cases. I'm going to skip the other 2 to just summarize and say that we filed these 3 cases together last month in October. We represent 16 survivors and families in these cases. So for all of the cases, yes, we identify this bigger pattern, is part of a bigger context around the war. But within that, we have clients who are suffered specific violations. So we represent 16 survivors or families of the clients who died. We name allegations against 21 commanders for sort of a range of crimes. And why Germany? So we filed in Germany, because, as I explained, sort of the universal jurisdiction laws are very strong in Germany. They're very favorable for victims or survivors who want to seek justice and who do want to go through a court process. And then the other reason is that we do have some of our surviving family who is located in Germany. So while they don't have to be, we could have submitted cases where no one was in Germany. It does make it sort of practically easier for German authorities to be able to reach people for testimonies, reach them for information, and anything they might similarly have on their phone, any documents or materials that they're able to share about what happened to them, or what happened to one of their family members. So these were the cases we filed. Just to note what would be possible in the US, just for these 3 cases. The US would not investigate any of these 3 cases as they stand at the moment, because the laws would not allow it. but there is a potential. And I always like to say, basically, war crimes cases are really like you're playing the long game. They're very long cases. Right. Some of the Rwanda cases are still being prosecuted today, or people are still being sought and looked for and investigated and prosecuted today for crimes that took place over 25 years ago. So we're all sort of playing the long game and putting these cases together, and hopefully at some point, the Russian commander is going to vacation somewhere where maybe there can be an investigation and prosecution. So that's sort of the potential for the U.S. If one of these commanders or any Russian commander or soldier comes onto U.S. territory under the new War Crimes Act, there is a potential to actually build cases there, which is very, I don't know, exciting. It seems wrong to say in this context, but sort of for accountability efforts, it's a very sort of hopeful consideration. So I think I'm going to conclude there today. And I'm happy to answer any questions about war crimes, universal jurisdiction, about the cases specifically, and anything else that's going on in Ukraine. And otherwise, thank you very much for your time.
Thank you, Antonia. Very much appreciate your presentation and your prepared remarks. Want to remind everyone that is joining us that they can submit questions to you through the chat window at the bottom of their screen. So if you are uncomfortable unmuting yourself, you can type your question, we'll relay that. Otherwise, if you'd like, you can unmute and ask a question directly to Antonia. Antonia, I guess my first question that we've received, you can maybe respond directly to. You mentioned there at the end how sub-processing cases are seeking criminals from the Rwandan genocide. Is there a regular timeline that you would expect any of the crimes that are currently being prosecuted for the Russia-Ukraine conflict to be settled?
That question is similar, I think, that we get from most of our clients. So it's a great question, and sadly, the answer is there's no known timeline. I generally think of things as happening in decades for international justice. Most investigation and trials historically have concluded in about 10 years, but that's such an average. Like I said, literally I think 2 months ago, they were able to arrest one of the key planners in the Rwandan genocide. And it's been over 25 years for that crime. Sometimes it takes, 3-4 years. So it could be faster. Some of the Germany trials have gone faster. But in those cases, it was also after, they were able to find some of the suspects either in Germany or extradited to Germany. So there's no good answer, sadly. I really wish I could give one. Also would love to give one to our clients. But I generally think about it in terms of decades, which is why most of the organizations or people working in this space focus so much on collecting and preserving evidence now, so that even if it does take 20 years, 30 years for the cases to proceed, you have the evidence, you know who to reach out to for testimonies, you have, saved videos, CCTV footage, anything that you're able to preserve now for a future case. But yeah, it's a good question.
And Antonia, can those decades be elongated by an appeals process, or is there even an appeals process when it comes to some of these courts?
Yes, yes, and yes. Yes, there are appeals processes for all courts. It's part of sort of the basic legal principles for the rule of law. For criminal, criminal proceedings, basically always have appeals processes to preserve the rights of the defendant. So any court, worth anything is going to have an appeals process, which includes all the international tribunals and includes even Ukraine. And yes, those will lengthen any proceedings for, another few years, possibly. Yeah.
Well, thank you.
Yeah.
I'm going to now go to, I see Bob or Lynn Fry has unmuted their account. Bob or Lynn, are you there with a question for Antonia?
I'm here. I'm not sure whether you can hear me.
We got you, Bob. Go ahead and ask your question.
Moving somewhat from the focus on the Ukraine, but still focusing on the new Genocide Act the U.S. passed recently. Some today you can read are accusing Israel of genocide in their bombing of Palestinian citizens, innocent women and children, 14,000 dead. And I'm wondering, and I'm not expressing a position on all of that, but as a lawyer myself, it occurred to me, my goodness, could an action be brought in the United States under that new Genocide Act by a U.S. Arabian-based citizen against an officer of the Israeli government here in the United States?
No, it's a good question, and I'm going to slightly limit my remarks because I also will not have a position, at least professionally, on this. But there actually have already been the Center for Constitutional Rights, based out of New York. They do great work around this topic, and they actually brought a case in the US. I'm happy to send around the link or send it to you if you're interested. They brought a case under the Genocide Act on behalf of US Palestinian nationals. And their argument, I mean, they will be able to speak much better about it than I can. I've only read a little bit on it, but their argument is actually against the US government about being an accomplice in genocide. They're alleging sort of US support of Israel is essentially accomplice liability for genocide. That is all I know on the topic. I'm happy to pass along that link, as they will be much more experts on the topic than anything I work on. I've really just been focused on Ukraine. But yes, like I said, this international criminal law, both sort of war crimes, crimes against humanity, and genocide, it's a framework that applies in almost any conflict or peacetime, sort of violations even during peacetime. So it's yeah, I welcome you to look at other conflicts and with the same sort of analysis. And I'm happy to send around more resources as well, if it would be helpful.
A second, less complicated question, perhaps, but we've also read that Putin is mysteriously absent and maybe will pass away soon or be replaced. My question is, would his successor be subject to the same claims, or would there have to be new claims dated after the point of that succession that could be brought against such a successor?
Yeah, that's a good question. So anything that he did basically would die with him. It's like the Milosevic trial that was started. Sorry, lots of speaking. Where the investigation and trial and prosecution began against him for the crimes that he ordered or conspired to commit during the Yugoslavia years. And he died during the trial, and the trial was essentially discontinued because the unique component of international criminal law is it's against the person, and if the person passes away, much like any criminal proceeding, the claims die with them. So if there is a successor, he would be able to, if the war continues, there's a lot of ifs, if the war continues and there are new crimes that are committed under, the direction of that new person, they would be responsible for those pieces. But otherwise, yeah, you would only be able to prosecute someone if they're alive and competent to stand trial, which is another piece of this, right? Especially as
Commander's claims would continue.
Yeah.
Okay. Well,
Yeah.
The lower level commanders, that you mentioned. Okay, thank you.
Yes, yeah, you would be able to do that. Mm-hmm.
Thank
It's
you
a
for the
very good
questions.
presentation. Thank you.
Thank you for the questions, Bob. I want to relay one question from another participant here, Antonia. Where do the accused stay while their case is active? Is there some sort of prison, or is there a bond for international criminals?
That's a great question. So it depends on where they're being accused. So if it's in a national court like Ukraine, the US, Germany, any of the countries that have these sorts of proceedings, it's their national system. So it would be, their prisons, their facilities. If it's the tribunals, I'm digging into my memory here, but most of them had some sort of agreement with the country they were sitting in to essentially use their pieces of their domestic system. So using their police, their law enforcement, their detention facilities, their prisons. I might have to double check that, but that's as far as at least the ones I'm remembering. It was part of the agreement that they would have some resources available for sort of, essentially cells to keep suspects while their trial is going on. And then the ICC has its own facility. So if we're talking about the International Criminal Court, they have their own facility in The Hague. So much like any country, they have essentially, resources to be able to accept detainees, keep them, while the procedure against them is going on. So it's kind of a normal part of the system to use those resources.
Well, thank you. And I apologize for anyone else who submitted questions. We are out of time. Want to let Antonia get back to her workday. But thank you all for joining us. I'm going to pass things over to Joyce Elferdink to send us out for the day.
Really, really want to thank you for making such a complex issue somewhat understandable to us. And I know, at least for me, it's very frustrating to know there's so much injustice, but we like to hear that, at least we understand the reasons why it takes so long and what has to be done to prove it. But I have a question too, is because your group, the foundation is working there, working in the countries, trying to gather information, trying to do your part to create justice. Is what you're doing in finding out, would that be private, or would we be able to have a way to learn what you're accomplishing?
So, sadly, a lot of it is private, but we do have some information about these, especially these 3 cases we just filed, our processes, how we work. If you go to our website and then go to the docket, you'll be able to sort of see some of the news around Ukraine, around other areas we also work in, but just basically because of confidentiality, to protect our clients, to protect our witnesses, to make sure, countries like Russia are involved in a lot of these crimes. We want to make sure people are protected and safe. So we don't give out a lot of information and no identifying information, but you are able to sort of see the work we do and how we do it, including in other cases on our website as well.
Thank you again. Thank you so much, Antonio, for sharing with us. I hope you can join us again, because we need the kind of information that you provide.
Thank you. Thank you very much again for this offer. I really, really appreciate it. And thank you for the great questions. And yeah, we will be in touch.
All right. Thanks.
Thank you. Thank you, everyone.
Thank you.
Thank you all.
Thank you.
Have a great rest of your day, everyone. We'll talk to you soon. Take care.